Good evening, everyone. My name is Benjamin, and welcome to today's video. Before we get started talking about SCOTUS, the Supreme Court of the United States, which is the topic I've decided to talk about, I want to thank everybody for continued support and discussion and, everything that's been going on with this channel. And if you are new to the channel and you like the content, likes, comments, subscriptions, they always do help, and I greatly appreciate them. But anyway, today we're going to be talking about the Supreme Court and how cases get to the Supreme Court, how they are decided, and the different sorts of cases and decisions and opinions and rulings that can be made. So I think we all know that originally the role of the Supreme Court was kind of vague, if we're 100% honest. You look at the Constitution, and the section on the Supreme Court it's tiny. It really is not substantial at all, and it really doesn't describe the role of the court besides a few different suits and hearing cases involving the federal government or the governments of the, quote, various states. So mostly it was just kind of there to handle disputes in that regard. But as a logical conclusion of the role of any court, which is not just to evaluate the guilt or innocence of a defendant, but they also have to evaluate the law as a natural conclusion of that. Because, sure, a person may be guilty by the letter of the law, but if the law is wrong in any sort of way or poorly worded to where a person who didn't really commit a crime all of a sudden finds themselves behind bars, and the law is flawed. So this is kind of the origin or the logical steps that lead to what eventually became known as judicial review. Now, everybody talks about Marbury versus Madison, stating that this was the first case in which judicial review was codified in the United States. Number one, that's actually wrong. There was a case prior to that where the court evaluated the constitutionality of a law. They just upheld the law. Marbury versus Madison was the first case where judicial review was used to strike down a law. In that case, it was the Judicial Act of, I want to say 1801 or 1800. I think it was 1801, or it was the Judiciary Act. And it was a specific section that gave the court original jurisdiction where the Constitution said the court could only have appellate jurisdiction. But they also ruled effectively in favor of Marbury, who wanted a writ of mandamus so that he could take up his appointment. The Jefferson administration continued to deny this because they did not like the dishonest way the Adams administration packed the entire federal court system, as well as other positions in the government that couldn't easily be undone or quickly be undone by Jefferson. Yeah, the election of 1800 is a gigantic mess, and it really deserves its own review. But the Supreme Court was not really, even after Marbury v. Madison, it was not really a strong branch like we currently view it. It wasn't considered a strong branch of the federal government. As a matter of fact, it was considered the weakest of the branches, followed by the president, where the legislature was considered the strongest branch. In the case of the Supreme Court, it continued to be a fairly weak branch for a while. The presidency got buffed by Andrew Jackson to where it all of a sudden became kind of considered the most important branch and the most powerful branch. But the Supreme Court really, I don't think people understood that its power wouldn't really be understood for a long time. Because you still have cases that were heard way back in the early days of the court that are used to explain modern rulings and modern opinions from the justices. Now, there are a lot of times when the Supreme Court makes a decision, and that decision defines future rulings on similar issues. And that's, of course, called precedent, because that's the first or the most significant thing, and it guides future actions and future decisions. Just like George Washington, choosing to only run for 2 terms. Truth is, Washington didn't even want to be president, but he accepted, and then he accepted again when he when he was volunteered to become president for a 2nd term. But he said after that, "No, I will serve no more." And that set a precedent that was followed, with a few minor sort of exceptions, until Franklin Roosevelt spat on Washington's legacy and decided to run for a 3rd and then even a 4th term. And I'm sorry I'm letting my anti-Roosevelt bias stand. Teddy also sort of tried to run for a 3rd term, but it would have only been it would have been acceptable under even the 22nd Amendment, because it would have only been his 2nd term of his own, even though he served for, I think, 3 years of McKinley's 2nd term. But anyway, moving back to the Supreme Court. Obviously, their terms are for life or until they decide to retire. And that has caused a lot of people to be upset, because you can impeach and I think even remove a Supreme Court justice through the same means as you can a president, but it is much, and it has been done successfully a few times actually, but the bar for removing a Supreme Court justice is considered actually higher than that of removing a president. The reason why there have been more cases of impeached and even removed justices is because, well, there's a lot more of them than there are presidents. But I would say it's probably harder to remove a justice, especially in the modern era, than it would be to remove a president. And there's a lot of reasons for that. The biggest one I'd say is that the Supreme Court is currently the most popular branch of the government. It has been for a very long time now. And that's because I think a lot of people actually believe what the court says when they say there are no conservative justices, there are no liberal justices, there are no Trump justices, Bush justices, other Bush justices, Reagan justices, Clinton justices. They're just Supreme Court justices. I genuinely believe that most Americans take the Supreme Court's word on that. Now, there are different ways that the justices interpret the law. For example, there are justices like the late Antonin Scalia, Kavanaugh, to some extent Gorsuch, and Clarence Thomas, who interpret from varying originalist stances. Now, people talk about originalism versus activism, and those are very broad terms, and they are very vague, if we're honest. For example, originalism can refer to the original meaning, it can refer to the original intent, or it can refer to the original text. And they all are slightly different in their nuance. For example, somebody who looks at the original meaning will comb through, historical texts to find what the actual wording meant at the time of certain phrases and all of that, as well as the writings of the people who wrote that section of the Constitution. Now, remember, the Supreme Court just deals with constitutional issues. They won't deal with, say, determining guilt or innocence. They don't care about that. They want to make sure that the procedure has been followed. For example, if you committed a murder, you can appeal all the way to the Supreme Court. And I'll get to how a case gets to the Supreme Court in just a bit. But if there's no procedural issues in your case, they're probably not even going to ask the question of should we hear it. And truth is, it won't get past the circuit courts if all the procedural issues have been followed. But if, say, you weren't made aware of your rights before you went to court, or you weren't provided adequate legal representation, or told that, you can defend yourself, but weren't given the option or weren't made aware of the option that you could have a public defender, then yes, the appeals court, the circuit courts and the Supreme Court would almost certainly look into the case. And that's what I mean by they really don't care about the guilt or innocence. They just want to know about the procedural. And stuff like that. Someone who follows original intent will do something similar to somebody who follows the idea of original meaning, but they want to look at what was the intent of the people who wrote that section of the Constitution or that amendment. And they'll look at supporting documents, similar documents with similar wordings to figure out, or other works by the person who wrote that section and say, okay, this is what that person intended. And such a law either abides by that intent or fails to abide by that intent. An original text person doesn't care about any of the intent or the meaning. They just look at what the text says and they say, okay. So that'll lead to some people, having some very idiosyncratic rulings, and it's why conservative versus liberal is kind of a poor way to break down the court and their varying views on jurisprudence. For example, you could have someone who wants to look at the original intent of, say, the First Amendment, and let's say someone had given a political speech and incited a riot, or was giving vaguely incendiary device. Somebody who looks at original intent is going to say, well, the founders had intended for this to be regarding peaceful actions of a political nature. They would probably be okay with a little civil disobedience, or maybe even some minor, say, property damage or whatever, at least as long as it is targeted against the government. Because we have to remember, the founders were totally cool with the Boston Tea Party, for example, and various Stamp Act riots, which were targeted against the British government. So somebody looks at original intent will say, beyond that, no. Whereas somebody who looks at original meaning is going to, or not original meaning, sorry, original text, or just pure textualism, which is the more common way I think it's referred to, or that I know it's referred to, is that I just phrased it dumb. They're going to, the textualist is going to say, Congress shall make no law that abridges the freedoms of, speech, religion, press, peaceable assembly, and petition. And they're going to say, this is expression. Congress shall, there shall be no law abiding it. And they're going to rule differently than somebody who says, yeah, this wasn't exactly peaceful. If you catch, so, yet both could be labeled as conservatives because of various other rulings they made, yet they're going to disagree wildly here. And you'd be surprised at how common that type of disagreement between supposedly similar justices are. And by the way, even in the modern court, there is a surprising amount of unity. There are just a bunch of different cases. There are just a few issues that there is a true ideological divide on. But anyway, let's move on to how does a case actually get to the Supreme Court? Well, first you have wherever the case was heard. And I'm going to talk about the most common way a case gets actually to the court. And either it can be a lawsuit against a state government, or it can actually be a criminal case. I'm going to use the more common but sometimes less consequential one, and I'll go ahead and use the current or the recently ruled upon case regarding faithless electors. So in Washington, of course, they have a law that pledges electors to vote for the candidate who won the state's popular vote, or basically to uphold their pledge to do so. Now, of course, each party selects the electors that will represent them, and this is permitted by basically every state. They don't have just a set number of electors. Each campaign chooses people who they believe will be loyal to them, right? And they take an oath and a pledge to vote for the candidate they are pledged to vote for. Well, in Washington, the punishment for violating that oath, in some states you get removed and replaced with one who will uphold that oath. In other states, Washington in particular, you get a fine. I don't think any state actually requires prison time for violating it. But, like I said, most often it's a fine to enforce it. I think most states would actually suspend that fine if, say, the person they pledged to vote for was found guilty of a felony, pretty obviously guilty of a felony, or, say, died before the Electoral College voted. For example, Horace Greeley in the late 1800s. I think it was Horace Greeley. It may have been Sam Tilden. You'll correct me in the comments. But anyway, so they filed suit, and because it was against the state Supreme Court, or because it was against the state government that they filed suit, saying that their First Amendment rights had been violated, it immediately went to the state Supreme Court, because it was a state issue at first. Well, after the state Supreme Court said, yeah, we can fine you for not upholding your oath, it's not a violation of your free speech per, I want to say the case was in the 1970s, where states could actually require an oath to its presidential electors. They immediately appealed to the Circuit Court of Appeals. Woo! Okay. The Court of Appeals upheld the state Supreme Court decision, stating, no, the precedent is fairly clear. Except it actually wasn't. And the reason why is because, sure, they can require an oath, but can they punish you for violating that oath? So they took it to the Supreme Court. Now, here's what happens when a case gets to the Supreme Court. The justices meet, and they have a gigantic list of cases from all across the nation, from all the states, all the courts of appeals, all the circuits, and they have to whittle them down to a workload that is actually manageable, because they all have to hear every single case that they decide to hear. Or, at least make the attempt to. Occasionally a justice will miss a session, or a few justices will miss a session, simply because they're sick or, family emergencies. So sometimes you won't have a full 9 justices, at least in the modern era. In previous eras, sometimes you had 7 justices, sometimes you had 5, sometimes you had 8, stuff like that. Anyway, they will, look at the cases, look at the merits of the cases, and this is where a few concepts that I have problems with actually come in. And those are, they will sometimes avoid hearing a case if they think the issue is too much in the political forefront of the nation, even if it's a case that really needs to be heard. Occasionally they will elect not to hear a case if the issue has been resolved through either changes in the law already or various other things. And this actually happened to a case this year, where the case was declared moot even after the justice had said, yeah, we're actually going to listen to this case, we're going to hear it, and we're going to make an actual ruling. They then decided, no, the case is moot, and there's no reason to hear it, because New York has changed its laws. But anyway, with the Faithless Elector case, this obviously wasn't an issue. Now, what the justices will do to decide which cases they're going to hear is they'll just hold a vote between the 9 of them, and for a case to get heard by the full court, in the way where they get together and they listen to oral arguments, they listen to they read the prepared briefs, the justices get to ask questions to each side. All they need is actually 4 of the 9 justices to say, yes, this case raises enough questions that we actually do need to hear it. So, yeah. You don't need a majority to get your case heard by the Supreme Court. Anyway, you move on to the next step, which is actually having your case heard. And you'll listen to, they'll listen to the oral arguments because they would have read the prepared briefs from both sides in the case, as well as the federal government's position, in cases where the federal government isn't heard. And in the case of the Faithless Electors versus the state of Washington, Washington was arguing that previous precedent was pretty clear that if you're going to be allowed to require an oath to vote for a certain candidate, well, you have to have some way of enforcing that. So, by the logic of the court's own precedent, requiring an oath, by extension, covers punishment for violation of that oath. The Faithless Electors argued, on the other hand, that the original text of the Constitution is supported and was intended to allow some discretion by the electors in order to avoid an unfit candidate from becoming president for various reasons, be they a demagogue or mentally unfit or too old or too young to properly, fulfill the duties of the office, or any other issue, or if a justice has or if an elector has supreme moral reservations about voting for a candidate. And they cited, I want to say, Federalist 10. But the idea was Alexander Hamilton's, right? As we all know, the court ruled in favor of the state of Washington, and I actually think they were dead wrong. I'm not going to get into why, but the original intent was to permit some level of freedom for the presidential electors. And the 12th Amendment does not change that. Now, the states are, of course, permitted to appoint electors in any manner they choose. It, however, is just that most states choose to appoint them via popular vote in that state. Because the state, and that was, of course, done by the state legislatures that decided, yeah, we're just going to have a popular vote determine where our electors go, rather than the state legislature vote on who the electors should be. But, the point is that, yes, times and culture and the nature of American politics has changed. However, the Electoral College still remains, and those sections of the Constitution are still relevant, and we shouldn't be ruling based off of what's convenient for us today. If we're going to rule on the Constitution, we need to rule based off of what the intent of the document was, using the meaning of the day that we can discern from the text and our knowledge of the time period. But anyway, that was a bit of a foray into my opinion on that. But That's basically how the Supreme Court operates, right? Now, there are varying levels of what's known as precedent, and some of them are extremely weak. Some of them are fairly strong. A weak example of precedent would be a plurality ruling. Now, a plurality ruling is actually possible where there's not a majority of the court votes on one side or the other, but they have the most votes, and this can be achieved via abstentions. For example, you can have a 4-3 decision become precedent or just become a ruling, right? And that's because, say, 2 justices abstained or just weren't present. This ruling, a ruling like this wouldn't have the same weight as a, 5-4, 6-3, or 7-2 decision, right? And that's because there wasn't a majority of the court voting in favor, right? Now, of course, we all know that there's the majority opinion and the dissent, but a plurality opinion can still become the official ruling of the court. It just requires some extenuous circumstances. There are also decisions which are just court opinions, which are the official ruling of the court. It's just the justices do not want to sign on to it. There was a ruling on cross burning in, I want to say, either the 60s or 70s, where none of the justices signed on to the official opinion, which was unanimous, and it basically declared that in the United States, hate speech is free speech. And I'm not kidding. That's actually Supreme Court precedent. These opinions are generally stronger than plurality opinions, but they are not as strong as a genuine majority. And of course, the number of justices signing on to the majority opinion make it stronger. The same thing could be said to a plurality opinion, of course. But, that's kind of just the very basics, right? And I think I should end this pretty soon, and I'm going to go ahead and just say I do, however, like that the current Supreme Court sessions have led to some really funny video conference moments. For example, Clarence Thomas referencing the Lord of the Rings in his questions. And also, Clarence Thomas has been more vocal in the video conference sessions of the court than he has throughout the rest of his tenure on the court. It's kind of funny, honestly. But the more you read various opinions, honestly, the more you get to realize that certain justices have certain idiosyncrasies. Thomas, some of his opinions are very good reads. I'll put it that way. Gorsuch has been ruling in a very civil libertarian way in general. I don't think it's exactly what Trump expected when he nominated him, but I think Gorsuch has actually been one of the better nominees in the court's history. But anyway, I want to thank everyone for watching. I hope you enjoyed. I'll see y'all next time. Take it easy. Have a nice day. Bye-bye.